star in the US, former movie producer Harvey Weinstein, has been found guilty of rape in a trial in Los Angeles. It's the second conviction for the one-time Hollywood kingmaker who became the face of Me Too sexual abuse allegations 5 years ago. The jury found Weinstein guilty of the charges involving one woman, but acquitted him of those relating to a second alleged victim. It was unable to reach a verdict on charges relating to two other women. The 70-year-old already is serving a 23-year prison sentence after being convicted of sexual misconduct in New York. The lawyer for the second alleged victim said she welcomed the ruling.
Today, justice was won in the case of People versus Harvey Weinstein. In this criminal case, I represented Jane Doe 2. Number 2 is Lauren Young, who gives permission to use her name, and Natasha M., who was an 1101B witness, which is sometimes called a Me Too witness or a prior bad act witness. Lauren was also a witness in the New York criminal case against Harvey Weinstein. I just spoke to her, and she's very happy that there were convictions in this case. And she also indicates that if, as, and when the prosecution decides to prosecute Mr. Weinstein again, she is willing to testify again in a third criminal trial against Mr. Weinstein.
Well, to look at this in more detail, I'm joined once again by Arise correspondent Laurie Laird. Great to have you again, Laurie. Mr. Weinstein's first conviction in 2020 was a landmark moment for the Me Too movement, so this is very much a sequel to a story that the world has already heard. But is this the end of the Weinstein trials?
To be fair, Charles, it is not the end of the Weinstein trial. Back in May, Harvey Weinstein was given, I'm hearing interference. I'm not sure if you can hear me clearly, Charles, but I'll carry on and you'll let me know. But
we can hear you loud and clear.
Mr. Weinstein was given leave to appeal his New York convictions. That opening oral arguments will be heard in those trials sometime next year. The court has not set a date yet. So after these two sets of convictions, we will hear an appeal in New York sometime next year. The feeling is that the oral arguments won't begin until May or later.
And Laurie, by the way, we can hear you loud and clear, but Harvey Weinstein's defense lawyers have in the past argued that these women had transactional relationships with Mr. Weinstein, which had led to transactional but consensual sex. I mean, would that be the ground for appeal in the New York case?
Interesting question, Charles, and that is not clear. When we got the result of the grounds to appeal, there was very, very little written about that, very little judicial opinion to give us a sense of what the grounds for appeal were. Some speculation that, and we heard the prosecuting attorney just a moment ago talking about this, it is fairly new in these cases, Charles, for prior past behavior to be included as part of a prosecution's case. So in the past, that has been that the only the accused can give testimony. Any let's say any prior accusations that are not filed as part of the current case until very recently could not be admitted into evidence. And in fact, only 16 states, including California, where this latest trial was heard, only 16 states allow any kind of mention of prior bad behavior. In the New York case, there was a special exception made to allow other people, and over 80 people, over 80 women did accuse Mr. Weinstein of sexual malfeasance. And some of those testimonies were allowed to be read in open court, despite the fact that these women were not were not formal plaintiffs in the case. So it may be something along those lines, because allowing admission of that past bad behavior is very new and slightly untested in the U.S. legal system.
And Laurie, in Britain where you are, I mean, there is much debate on keeping the identities of those accused of sex crimes quiet. I wonder if that damages the purpose of the Me Too movement, particularly outside the US.
And I'm glad you asked that, Charles. It's an excellent question because it shows how immature, in the early stages of litigation we are with some of these cases. Yes, the argument here in the UK is that people that men who are accused of sexual impropriety should not be named until they are indicted, simply because of the risk of accusing somebody who turns out not to be guilty down the road. And there have been a number of very high profile cases in the UK in the past couple of years where that has happened. But the whole premise of Me Too, the whole movement of Me Too, was within watching a high profile person being accused, that gave them the confidence to come forward and say, wait a second, this happened to me as well. I want to make sure that my story is heard. I am not going to suffer in silence. I'm going to make sure that this serial offender is heard for, is seen as what they are. So there are two sides to this, and this is something still being debated in the UK.
Laurie, thanks very much indeed. Laurie Laird, a Rice correspondent, talking to me there from the UK.